So I want to welcome everybody to another session of our SALT Talks. Tonight we're going to talk, Let's Talk Guardianship. And we have Hannah Neff-Reese here from the Montgomery County Probate. And she'll tell you a little bit about more what she does and a little bit more about the guardianship piece. So I want to welcome Hannah, and are you able to share? There you go. Make sure you can share your presentation. If you have any questions, feel free to drop them in the chat box. If you'll find your chat icon, or to pull up the chat box, is at the bottom in your toolbar. You'll see a little chat icon, and you can put your questions there as we're going through. Hannah, I asked Jim Harper to watch the chat box with me. Do you want, as questions pop up, do you want us to alert you to them, or do you want them all at the end?
Let's try to do them all at the end, because as we go through, a lot of the questions might get answered.
Okay. So we will, we'll go ahead and we'll keep track of all the questions, and then just, run through them at the end. So that's great. All right. I want to thank you for coming, Hannah, and I'm just going to turn it over to you.
All right. Well, thank you very much. All right. Well, welcome everybody. Thanks for coming tonight and listening to my little spiel. So my name is Hannah Neff-Reese. I am the Director of Guardianship from Montgomery County Probate Court. So just want to start by saying a couple of things. So one, I am from Montgomery County, so local rules are going to change from county to county. So things that I might say here tonight might not be applicable in your county, or there might be some modifications. So, if you are in a different county other than Montgomery, I would definitely recommend that you check with your local probate court on any of the stuff that I talk about. If you have further questions, just make sure to follow up with them, because it does vary from county to county. But for the most part, statewide, it's pretty similar. But there are a couple things that if you needed to follow up on, I would just reach out to them. And then a couple other, housekeeping things. So as an employee of the Montgomery County Probate Court, I am not able to give legal advice. So if you guys have, a case specific question and you're needing advice on what you would do or what you should do from the court's perspective, I am not able to provide that to you. So I can explain, the different processes, explain to you, what would happen in this instance or this instance, but I can't lead you to one side or the other. Okay. So we have to remain neutral. And then, like I said, we'll do all the questions at the end. I'll have time for Q&As, so we'll make sure to answer all your questions. If you do have case-specific questions, of course, this would be more geared towards Montgomery County that I could answer for you. But if you have case-specific questions, I'm going to share my contact information at the end of the presentation. So that will be a way that you guys can just write your questions down. We'll touch base after the presentation and make sure that if you do have any questions that are case specific that weren't answered, we'll talk personally outside of this, just to respect everybody's time while we're here tonight. Okay. All right, let's see. Let's go ahead and get started then. So the topic of tonight's SALT Talks is Let's Talk Guardianship. So a couple objectives that we're going to try to learn today, learning what is guardianship, learning why guardianship. There are different types of guardianship. So looking at the different types and seeing perhaps what might fit you or your loved one's situation. Learning about less restrictive alternatives. So guardianship should always be, the last resort, essentially. And then we'll talk about Rule 66, which brought about a whole bunch of changes in the probate court guardianship world. Those changes will apply to you if you guys decide that guardianship is something that you'll be pursuing for your loved ones. So we'll definitely talk about that. And then we'll kind of talk about your roles as a guardian versus your roles as a parent, kind of differentiating between the two, knowing when to put one hat on and take one hat off, different responsibilities. And then the application process. So if we go through all this and you're like, okay, guardianship is definitely something that I need to pursue for my loved one, we'll go through that application process. So it'll be pretty seamless. Again, this is going to be specific to Montgomery County. So you should be able to find the application for your county on your county's website. But if not, then you can definitely call that county's probate court and they'll help you with it. But generally the application process is pretty much the same. Our forms just might look a little bit different. And then at the end, we will discuss supportive programs for guardians that we have here in Montgomery County. And if you guys know of anything that other counties are doing, feel free to chime in. All right, so what is guardianship? So these are the legal definitions through the Ohio Supreme Court. So basically, Ohio Revised Code 2111 and Superintendent's Rule 6601. So there's a lot of legal jargon in here. So I put a little blah, blah, blah bubble up there. So it might seem, a little bit confusing or overwhelming just reading those, but essentially a ward is someone that is deemed incompetent. And so they could be deemed incompetent because of a physical, mental, substance abuse, some sort of disability that inhibits them from making their own decisions. Okay. So a ward is someone that has been deemed incompetent by the probate court. The probate court determines incompetency by, number one, your application that's submitted to the court, giving us the information that you have. And then number two, by a statement of expert evaluation, which is submitted by either a licensed psychologist or a licensed clinical psychologist or a licensed physician. So one of those two individuals would present something to the court or to you, and then you would present it to the court saying that this person is in fact incompetent and needs help with decision making. And then there would be the whole application process, going to court, making sure that everything checks out. And then, then that's how they would decide that someone needs to be a ward. A guardian is someone that is appointed to have responsibility over that person. So it's another court-appointed situation. A lot of times we have parents as they, have younger children with developmental or intellectual disabilities. They turn 18. They're like, well, I'm their legal guardian. But it's a different process once you turn 18. And we'll talk about that a little bit more too. But it is a legal process. You have to go through the whole legal proceedings in order to be appointed a guardian. And that's across all boards, not just Montgomery County. All right. So why guardianship? So we touched on this just a little bit, talking about being 18 or older. So if you have a loved one that is transitioning to adulthood. So let's say that they are, 17 or 18 or 17 going on 18. And at that point in time, you are able to make decisions for them, just like you always have in the past, right? So you go to the doctor, the hospital, they need treatment. You sign because you're their mom, their dad, their grandparents, aunts, whatever it is. You are their legal guardian and you've been able to do that. Once they turn 18, the healthcare system identifies them as an adult. Okay, so whether or not they are really able or capable of making those decisions or have the capacity to make those decisions, once they turn 18, that's when the hospitals have to have them make their own decisions, or doctors' offices or things like that. And that's where a lot of parents fall into complications, is when they take their daughter or their son to a appointment, let's say, and they're 18 and the doctor says, well, you can't come back, or you can't, have this information, or we need to prescribe something, but, you wouldn't be the one saying it's okay or not. That's where the guardianship needs to be put in place. So once you are appointed their legal guardian as an adult, then you have the authority to make decisions for them. Okay. So it's kind of where I think that a majority of you are at right now. I know Patty said that a large portion of the poll was 14 to 18. So you guys are kind of in that cusp of thinking about the transition to adulthood, thinking about what you guys need to do moving forward. And that's exactly what this is. Okay, so let's see. So there are several different types of guardianship. Generally speaking, there are only 2 or 3 that you all would have to worry about on a day-to-day basis. So guardian of the person only would be a situation in which you were responsible for making their health care, housing, and personal decisions, okay? You are responsible for the well-being of their person. The guardian of the estate is responsible for their finances, okay? So if they have any assets such as, a house or a car or, something, trust funds, something of large sums of money, you would have to be appointed guardian of the estate as well in order to make financial decisions on their behalf. Now, I will point out that this is a little bit different. Well, it's entirely different than Social Security income. So if your loved one only gets the Social Security disability every month, that doesn't qualify as an asset necessarily. So in that instance, you're reporting to Social Security each year, each month, however they do it. That's entirely separate. You don't have to report to the probate court for their Social Security income, okay? The estate is when they would have some sort of asset that would exceed the normal, Social Security disability or Social Security income bubble. So that's kind of a little bit of a differential there, but you can also be guardian of the person and estate. And that just basically encompasses both things that I just talked about. So their finances, their personal, housing, medical, all of that. Then there are limited guardians. So in the case of a limited guardian, let's say that you have a loved one that is able to decide and determine where they want to live. They are able to make their own housing decisions, but they are not able or don't have the capacity to make their medical decisions. You could be appointed guardian of the person limited to medical decisions, okay? Or it could be vice versa, limited to housing decisions. Maybe they need help with their housing, but they can say whether or not they're gonna, perform a treatment or take medication, if that makes sense. So that's where you might get a limited guardianship. The other 2 are emergency guardians. So this is a situation in which life or death, okay, so you have a loved one that is 18 to end of life age, and there is a life or death situation. They're in the hospital, they're in a coma, they need someone to make decisions for them immediately. Then you could go through that emergency guardian application process. Or if they are unsafe in that immediate moment and you are fearful that they, might not be safe if you continue to let them be in the situation they're in that day, the emergency guardian is there for that specific emergent circumstance. Okay, so once that emergent circumstance has passed, the emergency guardian only lasts for 30 days. Well, so it lasts for the first application and appointment is for 72 hours. So you have 3 days as the emergency guardian. Then you come back to court after those 3 days and you provide to the court an explanation as to should this continue for 30 more days or has the emergency been handled? Is there no longer an emergency? If it gets extended, then you would have it for an additional 30 days. And within that 30-day time frame, if they will need a long-term guardian, you would go in and apply for a person, estate, whichever one applies to your loved one, okay? And the emergency guardian does apply. So whenever you get appointed emergency guardian, it'll say whether you're a person, estate. So it's the same situation as the top 2. It's just for those immediate life or death situations. The only other time that you can do emergency guardianship is if there is financial exploitation involved. And it would be of great loss to them if it continued for any more periods of time. And then the last one on here is superior guardian. So Ohio Revised Code 211150 says that the court in the county that the guardianship resides has superior guardianship. So if, let's say, your loved one, you were the guardian of a ward, and they were at the hospital and the hospital was unable to contact you for any reason, they have the ability to reach out to the probate court and we can sign for treatments on your behalf. Okay, so we have the ultimate authority as the probate court to make decisions. So if there is something that isn't going well or isn't going right, and we have some concerns of, abuse or neglect or something along those lines, we can act in our role as superior guardian to ensure there are no gaps in care, no gaps in treatment, make sure that they are safe, protected, and, receive whatever it is that they need in that moment. So those are all the different types of guardianship. So one thing that I said earlier is that guardianship should always be kind of like the last resort. So not just us as a probate court, but across the board, everyone wants each individual to have as many rights as they can. So if one of these situations might apply or might work for your loved one, then that would give them more rights and more, just more rights in terms of what they can and can't do and make decisions for. So it gives them a little bit more autonomy. So the first being power of attorney. So a lot of folks that have, we see this the most in parents. So if, you're the guardian of one of your parents, or I'm sorry, if you are taking care of one of your parents and you're thinking, well, they might need a guardian in the next, 10 years. Mom's got early onset dementia, dad's got, bipolar, and we don't know where they're going to end up. If they are competent in the moments, they're able to sign those healthcare power of attorneys. And then that gives you the authority to make those decisions, just as you would if you were a guardian. But it still gives them autonomy in choosing who the guardian is, or the healthcare power of attorney or financial power of attorney is. They have more rights in terms of what they decide they do and don't want to do for treatments, housing, things like that. So that's a less restrictive alternative that we see pretty often. Another would be an advance directive. So again, the living will is something that we see a lot with folks that are with folks that are power of attorneys or next of kin to elderly individuals that might need a guardian or might need someone to help make decisions. So then there is a conservatorship. So this is when, in Montgomery County in Ohio, this is when you are physically infirm, but you are mentally competent. Okay, so you don't get to appoint, but you get to kind of express your wishes on who you would want to be your conservator if you were physically infirm. Okay, and you relied on them for all your medical decisions, and you relied on them for your housing, and you already relied on that person for everything else. A conservatorship might be something that they could look into, but it's something that they decide. So they would have to basically, I can't think of the word right now, but they would basically have to assign you as their conservator, and you would still have to go to court and go through that process, but kind of gives them a little bit more autonomy in that area as well. And then, as we talked about before, being a payee or an authorized rep, that is through Social Security income or Social Security Administration. So if you, feel like your loved one can really handle all their medical decisions, they can really decide where they want to live, they can keep their homes clean, they can manage their day-to-day, but perhaps they can't handle the finances piece, or perhaps they aren't able to do the adding and subtracting or figuring out, how much things cost. If their only income is that Social Security, you can go through them and apply to be their payee or authorized rep, go through that process. That also works for like Medicaid, applying for any sort of insurance, things like that. You can be their rep payee, their authorized rep as well. So what we always like to point out is that all less restrictive alternatives must be explored before we establish a guardianship. So when you come to court and you've applied for guardianship, the magistrate will ask you, why, do you think that a guardianship is necessary, as opposed to would a power of attorney not work? And it's not just you that they'll ask. They ask the court investigator to give their assumption. They ask the doctor to give their assumptions as well. So it's something that, everybody comes together and provides their best ideas of what would be best for that person. So this is where you kind of have to ask yourself, is guardianship right for my loved one? Or is there a less restrictive alternative that we might be able to work out? Okay. All right, so Superintendent's Rule 66 brought about a whole lot of changes in the probate court world, in the guardianship world. I am going to show you a video, okay? I'm going to share my screen and see how well it works. But I just want to point out really quickly that this video is outdated. So it was made, in 2014. So courts and other agencies were starting to become aware that there were a lot of cracks in the guardianship world, and there were a lot of wards or individuals under guardianship that were falling through those cracks or being exploited, abused, neglected. And there wasn't a lot of safeguards in place for those folks. So this video is, from when they started to determine those things. It's a dispatch video, and they actually did a whole investigation into it. Let's see if I can get this to work. Can everybody hear it?
No, I'm not hearing it.
Nope.
No sound. Okay.
When you did your share, did you click the two boxes? When you did a share screen, there was two boxes to click. It would let you do videos with sound. They would have been at the bottom left of the share screen.
Let me try something. Share sound. Let's try this.
There you go.
As guardian of the persons, it is your responsibility to protect and control the person of the ward, making all decisions on behalf of the ward based upon the ward's best interest.
The county probate court appoints guardians to protect vulnerable individuals. But a year-long dispatch investigation reveals once guardianships are established, the wards become trapped in a system ripe for abuse and neglect.
Ohio law doesn't say you have to visit and be involved with the person over whom you hold complete and total control.
While some counties in Ohio require guardians to visit their wards, the majority do not.
And what's sad is these are the most vulnerable people, really.
Most courts also don't conduct random inspections. Franklin County has more than 5,000 wards, and probate judge Robert Montgomery says they can't check up on all of them.
We have the resources to resolve the problems and investigate the ones we know about. I will say on the record that we really don't have the resources to go out there proactively and meet with every ward on a regular basis.
Phil Matoyer never wanted a guardian for his father Albert, who was an Army and Air Force veteran, but a local attorney applied for guardianship.
We were pretty blindsided because at that time we were told basically that this man was going to take over his guardianship. When you hear the word guardianship, you think about someone taking care of somebody. And it was my understanding that he was supposed to liquidate his assets, take care of his things, financials, and make sure everything was taken care of in an orderly manner. And I didn't see that happening.
That same attorney, Paul Cormanick, has about 400 wards under his control.
The first thing that comes to my mind is what happens if he gets hit by a bus.
We'd be running night court here 24 hours a day, 7 days a week for I don't know how long, having successor guardianship hearings just to try and place all these people. It's a system that's been in place for a long time. And as soon as I looked at it, I identified it as something that, you know, I'm not comfortable with.
Do you solemnly
The court expects guardians to be honest, but many wards can't question how the guardians spend their money. Attorney Kevin Crane had his daughter buy Christmas presents for his wards. Then they charged the wards for the gifts and the time it took his daughter to shop for, wrap, and deliver them. And the court approved it.
And if it's a $400 total purchase, typically it's $100 for the service and $300 for the item. They're getting paid to go, you know, see these people. And
Crane also routinely charges for the time it takes to file paperwork, which wouldn't fly under Judge Thomas Swift's rule in Trumbull County.
I will get an itemized bill from an attorney, and it will include time in transit to the courthouse. That comes off because that's not legal work. Time in preparing the bill, that comes off because that's your bill. That's not work for the wards.
While a few counties have set up their own requirements for guardianship cases, there aren't many state standards in place.
For us to expect that someone can come and be appointed guardian and understand what their duties are immediately is not a good assessment.
The courts also bear the responsibility of finding guardians for wards with nowhere to turn.
I don't feel comfortable as a judge being put in a position to where we feel like we have to somehow recruit people to serve as guardians and then call them in on the carpet if they've done something wrong.
Judges have the power to fine or jail guardians for neglect or abuse, but that hasn't happened in Franklin County in the last 14 years.
Judges in Ohio, by statute, are the superior guardians of the individuals they appoint. That's where the buck stops.
If the court isn't aware of a problem, how can it be fixed? Stark County has a volunteer program to check up on its wards, which helped identify a horrible situation.
When they found her, she was just basically crawling around the floor. Her daughter didn't see her every day, and she would leave food on the floor for her to eat. And if she knew she wasn't going to come back, she would put a couple diapers on her.
That guardian was removed, but finding good guardians to take on wards isn't easy.
When we live in the baby boomer generation here, where they're all going to be reaching an age to where we're going to have more people than ever are going to be in situations where they're going to have certain needs, there's going to be an incredible stress on the system when that happens.
Some say it's time for a change in thinking.
All of us will at some point become dependent, and we need to care about how people are taken care of.
It is very similar to the foster care problem. It is so similar. I mean, what you really have to have is people who give a damn.
As a practical matter, I think you're going to see that there's a lot of competing interests for any dollars that are available. I think you're going to have a change in thinking or mindset.
Okay. So can you all hear me again now? Okay,
Yeah.
Just want to make sure I didn't click on something that I wasn't supposed to. Okay. So like I said, that video is older, and that was, as they were starting to uncover a lot of these problems or a lot of these abuse and neglect, financial exploitation situations, actually as a result of that investigation in particularly, they uncovered an attorney, and his name was Attorney Cormanick. They uncovered that he had 400 wards under his care, actually over 400 wards under his care, and he was financially exploiting them. So no one knew about it for, a substantial amount of time, until this investigation kind of started to spark ideas that, hey, we should probably be having some sort of safety net to fall into to make sure that these wards are taken care of, because they are really one of the most vulnerable populations that we have. So out of that came Superintendent's Rule 66. So Superintendent's Rule 66 lays out a new framework for guardians. So this was put into place on June 1st of 2015. It applies to all guardianships in Ohio. It basically adopted a uniform framework for guardians. So this is where you'll see a lot of the requirements now that you guys would have as guardians. It also imposed new requirements on the probate courts. Okay, so there were different things that the guardians now had to do to ensure that the wards were being cared for. So things such as visits, making sure that they were seen at least 4 times a year by their guardians. Courts had to do things like allow the wards to have some way to write a complaint to the court to make us aware of situations if we weren't before. So this is a little quote from Chief Justice Maureen O'Connor about this investigation, and it just says, the result of countless hours of work from the committee members are rules that will align Ohio with the standards set by the National Guardianship Association in adult guardianship cases and raise the level of professionalism amongst our guardians. So this is going to be a Montgomery County. So Superintendent's Rule applies across the board for the state of Ohio. However, there are many sections of Superintendent's Rule 66 where it says that local rules for each county can modify specific things. Okay, so these are kind of how Montgomery County has modified these specific things. Okay. So for guardians, like I said, guardians are required now to visit their ward every 3 months. So I know for most of you, that's not a problem, but it is something that if you had 400 wards, you wouldn't be able to do. So just making sure that there's, checks and balances, that they are visiting with their wards or loved ones, at least quarterly. The second requirement that came about from this is that guardians are now required to report to the court each year. Okay, so there are 2 forms that are submitted to Montgomery County Probate Court each year if you are the guardian. So the first form is the annual guardians report. Okay, so that basically tells us what happened in the past year. Have there been any changes in the level of care that your loved one is receiving? Have there been any changes in their, health status? Have they seen a doctor in the past year, 6 months? Have they moved addresses? Are they still residing somewhere? Has there been a big change? Essentially, we want to know, how the last year went. And then the annual guardianship plan is the other form. And that one is what your plan is as a guardian for your loved one for the upcoming year. Okay, so there's questions in there that says, do you plan for your ward to receive transportation services, vocational services? Will they have visits from family members? Will they change residential settings in the next year? Things like that. We want to know what your plan is as guardian for the well-being of the person that you're serving. Okay. And then what we put in there also is that this was a requirement even before, but a statement of expert evaluation, which is completed by either a doctor, a licensed clinical psychologist, a licensed clinical social worker, someone on the DD team, so like your SSA, they have to complete that expert evaluation statement every 2 years, every 2 years. That says that they feel from an outsider's perspective that guardianship is still necessary. So this is just, one of the most important safeguards that we have in place, because if a doctor says, hey, this person doesn't need a guardian anymore, and we have a guardian that says, yes, they do, we need to figure out what the differences are there and why we have these two different opinions. And then make sure that they're not being exploited, because, you know, as we've said before, guardianship is the most restrictive option that you could take. So it takes away all of their, or not all of, but many of their rights. So we want to make sure that they, that we know what's happening the year past, the year going forward, and then that statement of expert evaluation. Another requirement that it put in place is guardian education. So a lot of these guardians that had been serving really had no idea what they needed to do in terms of legally as a guardian. So a lot of them were like, yeah, we're parents, we've been the parents. I'm sorry, I have 2 dogs and they bark. So the education also lays out in detail all the different requirements that you have as a guardian with the changes put forth in Rule 66. So it'll lay all that out for you in the education, but guardians are now required to complete a 6-hour fundamentals course within their first year as guardianship. It says within 6 months. It's in Montgomery County. This is going to be one of your county by county things, but in Montgomery County, we are not sticklers on if you're not in 6 months, you're in trouble, you're coming to court. You know, we give you guys the first year to make sure that you all, you know, have the adequate amount of time to get your education completed. And then each year after that, they would complete a 3-hour course. So those are just continuing educations, and there are many different topics. So there's things that, you know, talk about government benefits. There's some that talk about dementia and Alzheimer's. There's some that talk about guardian of the estate reporting. There's all kinds of different educational options. In Montgomery County, currently, these are still being offered in person. We offer the 6-hour fundamentals course once every quarter, so 4 times a year. And we offer the 3-hour courses each month throughout that year. So aside from June and December, so we'll hold 10 courses throughout the year. 4 of those will be fundamentals, and the other 6 will be continuing educations. And then in addition, one thing that Montgomery County does do for guardian education that I have not heard of any other counties providing yet, we offer a support group for guardians, which we'll touch base on a little bit later in the presentation. But that support group we offer once a month, and it does count for 1.5 hours towards your continuing education. So if you came to 2 months classes, you got 2 1.5 hours, you would met your 3-hour requirement. Now, one more thing that I do want to touch on with the guardian education, if you are a family member of your loved one, you only have to complete your first year with the 6 hours and then 2 more years of 3 hours. So once you've completed 3 years total, the 6, a 3, and a 3, you're finished with your education. Now, that's not to say that you can't take any, and we will certainly welcome you at any of our classes, any of our support groups. But in terms of what you're required to do, it would end there. Okay. But if you are not a family member, then you would have to continue to do 3 hours every year. Okay. All right. So that's also all offered online through the Ohio Supreme Court. So they have the 6-hour educations. They have many, many 3-hour educations on there. So if you are in need of, you know, one of your requirements to be met and you haven't, or you don't see one on our calendar that might meet in your time frame, number one, we're flexible and we want to work with you. But number 2, you can always do it online as well. Okay, and then changes of residence. So this is a new requirement from Rule 66. This just says that if your loved one changes residence, you are required as the guardian to tell the probate court. This primarily relates to if your loved one goes to a more restrictive setting. So if they are living in their own apartment or their own home or with you, and then, you know, the time may come that they need to live in a residential setting, you would submit that application or notice of change of residence to the court so that we can make sure that this more restrictive setting is something that is actually benefiting the ward. Okay. Again, just another safe gate to make sure that we aren't just putting everyone away and, you know, locking the key to where we don't know what's going on. And then the last one there is abuse, neglect, and exploitation. So this just lays out that guardians are now kind of mandated reporters to report any sort of inappropriate abuse, neglect, or exploitation to the probate court. So, you know, that could be done differently in each county. In Montgomery County, we have a guardian's complaint form that you could fill out, or you can notify the court via phone or in writing. Okay, so these are a couple other requirements from Superintendent's Rule 66 that we didn't put on our little sheet because they're a little bit more case specific. But one that is really important to you guys is the direct services provider. So in the state of Ohio, you cannot be a direct services provider, meaning getting paid for taking care of your loved one, and be their guardian, because that brings a conflict of interest to the table where you are getting paid for and determining the level of care that they receive. And we want to, again, it's another safeguard to make sure that they're not being exploited or abused or neglected. However, local rules state that, and again, this is going to be different county by county, but in Montgomery County, if you are a relative to the ward by blood or adoption, then you are able to apply to the court to become the direct services provider, even if you are guardian. So we can approve it, and it's just case by case. So you still have to go through all your certifications and your trainings through the state of Ohio. You still have to, you know, do whatever kind of supervision and upkeep and classes and whatever it is that you have to do there. You still have to comply with all of that. This would just be the probate court saying, yes, we see that there's not a conflict here. This is the best interest for the ward, and we're approving it to make sure that, you know, everything is kosher. So I'll probably have some questions on that. So I'm sure we'll talk about that a little bit more later, but Jim is your guy to reach out to for that one also. All right. So another thing that is required is if you are the guardian of 10 or more wards, you have to register with the court every year. That way the court can keep track of who you're guardian over, why you're guardian of more than 10 folks, and if you've met all your requirements for each of those individuals. And we can kind of keep a closer eye on that. Reporting conflicts of interest. You have to file a list of important legal papers. So if, you know, the ward has a living will, the ward has healthcare power of attorneys, advanced mental health directive, things like that, you would just file a copy of those with Montgomery County Probate Court. Again, you know, making decisions that meet the ward's needs while imposing least limitations on their rights. So that's something that, you know, we're all big advocates for, is making sure that we are not stripping these individuals of every right. Okay, they still have, you know, the rights of adults in many aspects. Let's see, the rest of them they're pretty much the same as they were before, but just maintaining confidentiality, honoring their preferences, you know, ensuring that they have positive relationships, all things that as a parent or a grandparent or family member, you've probably already done for the last, you know, 18 years. But these are just things that are now in writing for the best benefit of the ward. So now these are the front pages of our reporting requirements. And this, again, is Montgomery County specifically. So if you're in another county, you'll have to look at your court's website. But for us, this one here on the left-hand side is the Guardian's report. This is just the front page, but it is a 2-page paper, mainly just check boxes and fill in the blanks, asking you if anything major has changed, what their residence is, you know, who they reside with, if it's changed, if it hasn't changed, if they've seen a doctor. Pretty basic, simple questions that You guys shouldn't have any issue answering. And then the one on the right is the annual guardianship plan. Now this one is 4 pages. However, it's not as daunting as you would think it would be for 4 pages. In fact, the last page is entirely for guardian of the estate only. So if you're not guardian of the estate, that's one less page that you got to worry about. But this just asks questions going forward. So again, it confirms that their medical conditions haven't changed, their date of birth, making sure this is, you know, all kosher on the front end. And then it just asks about their functional abilities. And then on the next few pages, it'll ask what your plans are for them. So will they go to day program? Will they continue to live with you, or are you looking into residential settings? Things like that, okay? And these forms are available on our website. We can also mail you a copy if you need us to mail you one, or I can email them to you as well. But so the report and the plan are due each year on the date of your appointment, on the anniversary of the date of your appointment. So let's say that you are appointed guardian of Johnny on January 1st, 2021. On January 1st of 2022, these 2 forms would be due. Okay, and then it would just be each year after that. The statement of expert evaluation. This is what the doctor or psychologist or someone on your DDS team has to complete. So it lists, you know, which person is completing the form. So they would just check that off, and then they fill it out entirely. All that they do is provide you with the original so that you can file it to the court. Okay. But this is due every 2 years on the anniversary of the date of your appointment. So again, let's say you were appointed guardianship of Johnny January 1st of 2021, January 1st of 2023, you would then have to complete, or you would then have to submit the completed expert evaluation. Okay. So the other 2 forms are due every year, and this one is due every 2 years. Now for the education piece, again, this is going to be specific to Montgomery County, but this is also going to be due every year on the anniversary of your appointment date. So January 1st, 2021, January 1st, 2022, you should have completed your Guardians Fundamentals course, your 6 hours. And then January 1st of 2023, you should have completed and submitted a 3-hour course. And then the same for the following years. So there's a couple different ways that you can get these completed. So our website is right here. It's the https://mcohio.org/probate. So that is Montgomery County's website specifically, where you can go and look at our calendar and see what our in-person offerings are. All of our educations right now are offered at Madison Lakes Learning Center in Trotwood. Now I will say that I haven't found a county yet that would not accept something that we provided if it was what worked out for the guardian. Okay, so if you came to ours, of course, I would check with your probate court first to make sure that they will accept it, but you're more than welcome to come to ours even if you're out of county. Okay. And then for online trainings, this is the website and link for the Ohio Supreme Courts. Now they have, you know, probably a couple more 3-hour education offerings than we do. But you can also check with local agencies to see if they have any educational offerings. So this SALT Talks counts as an educational requirement. I'm not sure if I think it's just the 3-hour course, Jen. I'm not sure, but I know that it does count towards it. So if there are other courses that are being offered, you know, through Montgomery County Board of Developmental Disabilities, and that was something that was of greater value to you than something that we might offer, absolutely. You know, as long as it applies to you learning and continuing your education as a guardian, then the court really wouldn't have a reason to deny that. Okay. Okay, so for the notice of change of address, this is what the form looks like. This is due anytime that not only your loved one changes addresses, but also anytime that you change your address. So this is the formal way that the court updates and keeps record and track of where our guardians live, where our wards are, how to ensure that everyone is in the best setting in terms of maybe you moved out of county and it would benefit you guys to transfer the guardianship case to the county you're in now. Or, you know, perhaps the ward no longer lives in their own apartment. Maybe they live with you now. So just ensuring this is how we are able to document. Okay. The guardianship complaint. So this is what the court had to come up with. We had to make a process for wards to be able to file complaints against their guardian. So prior, they were pretty much voiceless in terms of if they had concerns or if someone else had concerns against the guardianship. This is the form that they would be able to complete. So it's 3 pages. This one is just the front page, but just asks kind of what the issues are. And then at the end, it gives you, you know, a little blurb space where you can write out what your concerns are. And I will say this, as a guardian, if they have a complaint, even if it's against you, you might have to be the one to help them write that complaint. So, you know, because they do have the right to this, they do have the right to submit their, you know, every concern to the court. And you might be the one assisting them in completing and filing this. Now, once a complaint is filed, the guardian is given 10 days from the day it's filed to write to the court their response. Okay, so, and you will be notified of any complaint that gets filed. The guardian immediately gets notified and then is given 10 days from that date to write a response. After those 10 days are up, whether the court has a response or not, we review all the information that we have. We determine if a hearing would be necessary, or perhaps just a visit from one of the social workers on staff would be necessary. Or if we need to do more investigation. So if we need to talk to, you know, other folks that might be involved. So neighbors, doctors, day programs, home health aides, things along those lines. Okay, so that, and then if the magistrate decides that a hearing is necessary, he would bring all parties in, you're notified, you would, you know, attend court, and then they would just talk about what the plan is moving forward. So, you know, we've had complaints filed that just say, I don't like my guardian, or, you know, my guardian doesn't let me eat all the brownies I want to eat, or, you know, it could be something as simple as that to something, you know, as outrageous as abuse and neglect that the ward is letting us know about. So that's our process for investigating complaints and for giving the ward an opportunity to express their complaints. So this is the application for direct services provider. So this is, again, kind of what we talked about before, where you can't be getting paid to be the ward, to be the ward's direct services provider and be the one making the decisions as to who gets paid to be their provider, making sure that conflict of interest is there or isn't there. But so this only applies to you if you are an independent provider through the state of Ohio and receive payment for the services you provide. Okay, so you have to go through your certification process. If you're a licensed independent provider, you've been certified, you're able. And then the other is if you are of close relation to the ward, either by blood or adoption. All right, so we can't just have, you know, a friend that comes in and is like, oh, I'm going to take care of them. Oh, and I'm also going to decide who takes care of them and gets paid for it. We want to ensure that there's no conflicts of interest there. Now, I will say that it's ultimately going to be up to the judge whether or not these get approved or denied. Generally speaking, the judges are understanding of the fact that perhaps, you know, you're the parent, you know them best, you provide their services anyways, you've been doing this for so long, you know, or perhaps it prevents you from being able to have a full-time job or a part-time job because you are providing care to them. So that would be where the court is understanding of that and is going to waive that conflict of interest and make sure that you are able to do both. Okay. All right, so as a response to Rule 66 requirements, Montgomery County Probate Court has created an entire guardianship department. Now, I don't know what this looks like across all counties, so you'll have to check with your counties individually. But our guardianship department consists of 4 individuals. So I am the director of guardianship. We have Miss Nicole Land. She is one of the new social workers on staff. We also have Jackie Porter, and she's a court social worker on staff as well. And then we have Jonique Springer, who is our court investigator. So each of us play a little bit of a different role, but we also often overlap. So there are 4 magistrates at Montgomery County Probate Court. Each one of us on the guardianship department has a magistrate assigned. Okay, so let's say you go to court and you are assigned Magistrate A. If you have a concern or a problem with your case, or even just a question of when things are due, you can reach out to your court specified social worker based on your magistrate, and they can work with you. Okay, so that would be one of the 4 of us. We would make sure that all your questions are answered and we have all your needs met as a guardian. We're also there to provide supportive services in terms of, sometimes they might need guidance as to what their options are. Again, we can't give that legal advice to you. So unfortunately, you can't come to us and say, hey, I need help completing this form and I need your help, or what's the best wording to put on this form. We can't guide you to legal advice, but we certainly can give you explanations and try to explain things in different lenses, because sometimes, the legal world is complicated. So that's one way to do that. And then the magistrate will let you know who your court-appointed social worker is at your guardianship hearing. So you'll be able to identify them and make sure that you're able to get in contact with them if needed. You can also always just call the main court's line. One of the girls up front, one of the clerks, they know whose magistrate has which social worker, so they can easily guide you to either one of us, okay? All right, so now I just want to talk about the guardianship application process a little bit. So let's say that, you're here, you have decided that, yep, there are no less restrictive alternatives and guardianship is necessary for my loved one, and I need to know what I need to do to apply and move forward with this. So this is where our application can be found. Again, Montgomery County only. I would assume that many applications can be found across the board on websites for each local county. But once you go, you'll see all of our application forms. So I believe there's 13 documents. Not as daunting as it sounds for 13 documents, but one of them is in fact a background check. So you do have to have a BCI completed in order for us to appoint you as guardian. There are specific things that perhaps would disqualify you as a guardian, but there are also case-by-case situations where, depending on the amount of time, relationships, things along those lines, we just want to make sure that we're aware, and we want to make sure that, we continue to ensure the best for the wards out there. There will be a court hearing. So let's say you've completed your whole application packet, you've done your background check, you've submitted everything to the probate court. Once you've completed all of that, you will be giving a hearing date and time. You have to attend the hearing if you want to be appointed guardian. Okay, so just completing the application isn't enough. You have to physically be there in front of the magistrate or the judge, and they want to make sure that everything that's written on this application is everything that checks out to be when he approaches you in court or she approaches you in court. At the appointment hearing, it's not a long hearing, it's pretty brief, only about 30 to 40 minutes. They will review everything with you. So they will go over your application. They will go over that expert evaluation. So that doctor's statement that says, hey, this person would benefit from a guardian. And then they also go over the investigator's report. So when you apply for guardianship and you get your hearing date, an officer of the court investigator, which is Jonique Springer, goes out and sees your loved one. She notifies your loved one that someone has applied for guardianship over them. She notifies them who it is, and she gives them a list of their rights in terms of this guardianship hearing. She also gives them the date and time. So they are absolutely more than welcome to come. And if they decide that they do want to come, it's going to be up to the applicant to make sure that they get there. Okay. So they'll review all that with you in the hearing, and then they will discuss everything with you. So they want to make sure that you understand, what the ward still can do. They want to make sure that you understand what your roles are as a guardian. So a lot of what we just discussed tonight, they'll want to talk about, that you have to submit reports, you have to complete visits, you have to do education. They want to make sure that you're prepared and you are able to accept the duties. And then they'll discuss that role transition with you again, being the parent or legal guardian of someone as a minor versus adult and competent. And then at the hearing, you'll also be given a folder. This folder consists of the Guardian's Handbook, which is a great resource that was put together by Governor DeWine, as well as many other people, just kind of making sure that you all understand everything about guardianship that there is. So you'll be given a copy of that. You'll be given a copy of several forms that you might need. So I think the report and the plan are included in there, so you don't have to find them the first year. And then other helpful information. So it might give you a list of all the classes that we have for the upcoming year. It might give you a business card with the director's information if you have questions. It's mainly just an information packet to you to make sure that we're providing you with as much tools in your toolbox as possible to make sure that this goes as successfully as possible. So now this again is specific to Montgomery County, but we have a couple supportive programs for guardians. So the first one is an application review. So let's say you've completed your application, you're ready to turn it into the court, but you just want a second set of eyes, or you want to make sure that everything is correct, filled out correctly before you do file it with the court. So at this application review, we offer it at no cost to the applicant. Right now, because of COVID, we're only doing it by request only, but essentially you would just request that the court staff attorney meet with you and go over your application with you. Now, again, they can't give you legal advice, so they can't say you need to do X, Y, and Z, but they can make sure that everything flows smoothly, is laid out correctly, make sure that there's no blank boxes, that there's no reason it would be rejected, essentially. Okay. So that's one service that we do offer here in Montgomery County. And we've had a lot of folks that really benefit from that. But I think Montgomery County also has its own little application reviewer with Jim. He's pretty great about helping folks out with their applications. So let's see. Another supportive program is the Guardian email form. So what this is just a reminder, a courtesy reminder, letting you know that, hey, your report and plan are going to be due in 90 days. Your plan and report are going to be due in 60 days, because we understand as a court that a whole year is a really long period of time for you to remember that you have to complete, 2 forms, or when you have to complete those 2 forms in your education by. So this is just a reminder. We always say, please note that it's still your responsibility to keep track of your due dates. There is, technological error, human error. We might enter a digit wrong on your email address and you might not get it. It's still your responsibility to keep track of your dates, but this is just a courtesy program for you guys. And then Coffee and Conversation is one other supportive program that we offer for guardians. So this is actually a support group for guardians in Montgomery County. So we have a lot of guardians that come together every month on a Tuesday night. We meet the 4th Tuesday of every month from 5:30 to 7. Currently, they are being held virtually due to COVID. We're hopeful that those will resume in person at some point in the future. but it's an informal support group where guardians can share their knowledge and experience with each other. So, we want you guys to be able to network. We want you to be able to share experiences. One guardian might have gone through something that another is going through now, and we just want to try to provide as much support to you as possible. So that's one thing that we offer. And then that's wrapping up the end of my presentation. So big thank you to everybody for sitting through this. I know that was a long spiel, but essentially, I want to lay out the rest of the time for you all to answer questions. So I know that there's several things in the chat box, and I'll try to go up through there and look. But additionally, I put my contact information down here on the bottom left. Go ahead and write that down. More than happy to answer questions for you. Like I said, if they're case specific, we'll try to keep those individually between us. So you can reach out to me by phone or email, and I'll touch base with you individually just to be respectful of everyone's time.
So
Right.
Hannah, this
Yes.
is Kathy Kleiser. I wrote down all the questions so I can read them to you so you don't have to hunt them down.
Perfect. Thank you so
Okay.
much.
So the first
Wonderful.
one is from Sue, and she says, can you use a power of attorney without an attorney? Can you get a power of attorney without without an attorney? Can you do
Yes.
that?
Yes. Yeah. So
Okay.
you still have to get it notarized, and it still has to be, official in terms of the correct forms and everything. You can't just type something up on a Word document and expect it to fly. But yes, you can go through that without an attorney. Absolutely.
So then Marie asks, can more than one person have a power of attorney over a person?
So the way that power of attorneys work is it identifies the individual's top choice, essentially, or the individual's, I can't think of the exact word that they use, but their primary, basically. And then it determines, in the instance that this person were unavailable or unfit or unable, this is the backup plan, and it gives the next person. So they would still, have that first person as their top choice, but you are able to have two names on there. And I think a lot of power of attorney forms even allow for 3 names now, in the event that A or B were unable to provide the support needed.
Okay, and then after that, Antoinette, I believe, asked, how early can parents of children who have significant disabilities apply for guardianship, those with very significant disabilities?
So the individual still has to be 18 in order for us to appoint a guardian. Now, you could apply for guardianship, let's say, 3 months before they turn 18, but we wouldn't be able to appoint you until they are 18. So if you applied at 17 3/4, we would give you a court date. And if they aren't 18 by that court date, we wouldn't be able to appoint you. So you'd have to have another court date. That would kind of be unpleasant.
Okay, as a follow-up, and I'm just going to, before I go to the next one, to follow up from her question, because I have this question from a lot of parents with kids who have significant disabilities. They're, and we're in Greene County, but they're very worried about making sure that guardianship is in place. A lot of people very uncomfortable. What if it doesn't happen right at that date? What's going to happen? And I try to assure them that if you can expand on that a little bit, because I know there are a lot of parents that are very concerned about that. I talked with one today, wants to make sure it's in place on the day they turn 18. And once again, this is specifically those kids with very significant disabilities. What happens if they're a day late, or even 6 months late, or a year? I mean, just that question.
So in terms of like medical decision making, so let's say the day before their 18th birthday, they go to the hospital and they are unable to make decisions. In that instance, Well, let me first start by saying that we do have that emergency guardianship process. So should that individual go to the hospital on, the day of their 18th birthday, and mom and dad do not yet have guardianship, or 6 months after, they can apply for that emergency guardianship. It's granted same day. I mean, given that, all requirements are met, it would be granted same day. So they would have that immediate authority to make decisions on behalf of that individual. So that would last for that 72 hours, that 3 days, 3 business days. And then we would come back and determine if it should be continued for 30 more days, while perhaps they apply for regular guardianship, or while perhaps they're awaiting their guardianship hearing date. Does that make sense?
I think so. And there might be parents who have follow-up questions with that.
Okay.
Going on to the next one. Somebody asked, are the classes, or are there topics, is it a specific class, or are there actually topics to choose from?
There are many topics to choose from. So for the first year, when you complete your 6-hour fundamentals course, that one actually is baseline. That one, you don't really get a choice on it. But each year after that, there are many different topics that you can choose from. So there's some that talk about government benefits. There's some that talk about mental illness and medications. There's some that talk about dementia, the DDS system. There's all kinds of different topics that you can choose from.
Okay. And then Jerica had 2 questions. What happens, number 1, if a family didn't complete the required 2-year form? Would the guardianship cease at that time?
No. So the process, whenever a guardian does not complete their requirements, and now this is for Montgomery County, so I can't speak for all, but generally speaking, we would send you a reminder or a notice after 30 days of it being due, saying, hey, this was due on this date and you need to complete it by X, Y, or Z. If that time frame, continues to lapse, then the court kind of looks into it a little heavier, start calling the guardian, trying to visit the guardian, maybe seeing kind of what's going on, checking in on the ward to make sure the ward's doing okay. But we would just continue to work with the guardian to make sure that they are able to complete those forms. And then once we are able to get everything in, it would just count back to that date, if that makes sense.
And as a backup, I do want to say for our Greene County people, those rules are slightly different as well, depending on if you're a parent of a guardian, you're a parent and you're a guardian of a individual with a significant disability. There's some differences on how often the education piece is. So as Hannah said, make sure that you check with your county. And I put in our chat box the website there, and there's a booklet in there that they have that you can look those kinds of things up and ask those questions for Greene County as well.
Yeah. And in the instance where, let's say, we have tried and failed to get these completed and it's been a substantial amount of time, the magistrate might say, okay, let's hold a show cause hearing. And at that point in time, you would be notified, and you would come to the court and provide the magistrate some explanation as to why you should or shouldn't be removed as the guardian for not completing the requirements. But like I said, in Montgomery County, we tend to work with you. We, want what's best for the wards at the end of the day. So, if you just forgot that it was a year and we're working on it and you've got it in the next, X amount of time and you've complied, no problem moving forward.
And then the last one that I copied down, it was 2 questions. They asked, can a guardian that is also a Social Security payee also open and manage a stable account for their adult child?
So that is a question that I do not know. That might be, that's not really a probate court matter, I guess is the best way to put it. Jim, you might have a little bit more insight on that one.
Your best bet there is to contact Doug Jackson. He is the head of the stable account for the state of Ohio. In each different county, they've worked out different ways around that. So I don't know where the individual is from as to which county, but yeah, if they call up to Doug, and I can get Doug's email address to Patty, and she can send it out to the families. And then he can answer that directly as to, you know, the person's location and what's the best route for them to do.
Yeah, and we have stable account. We will be talking about trust after some of these guardianship. Let's see, October, November, we talk about stable account and trust. So we will be having someone discuss that coming this next month.
Awesome.
And then I think, Hannah, you already addressed this, but you may want to say it again. When and where are the support group meetings?
Yeah, so currently they are being held virtually. So they're through what we use as go-to meetings, pretty similar to Zoom. The fourth Tuesday of every month from 5:30 to 7. And the link to register for those is on the Montgomery County website. Or if you want to reach out to me through email, phone call, or reach out to the main line at the probate court, we can also register you that way.
And Jim, I don't know if you can you put your contact information in the chat box? Are you able to? Okay. We'll look it up and see if we can get it in there.
And Patty, aren't you having somebody from Greene County talk, Brittany O'Dime, later on from Greene County, so she could address specific questions that they might have?
Exactly. That she'll be. We're really hitting the guardianship piece quite heavy this fall. So Greene County will be. It's in December. They're ending the. We're focusing on what happens when we are gone. They'll be coming to speak in December. We also have in 2 weeks APSI speaking as well. And then November we'll have some presentations on trust and stable account, like I mentioned.
You guys are wonderful. You have such a wide variety of information for all these folks.
They seem all connected. All these topics, they connect in some way or another. They overlap and they web together. And it's like, we just want to make sure everything is covered. And so Social Security won't be till the end of the year, but we do try to, overlap things as much as possible.
Yeah.
Does anybody else have any questions out there? I think we got them all that were in the chat. I'm going to go ahead and end the recording for us so that if anybody doesn't want to type it out, they can just ask their question. But I just wanted to remind everybody before I ended the recording too, or while I'm ending it, I just want to thank everybody that came tonight and attended. If you are here as an SSA, we did get approval for CEUs. If you did not have a question, like come up in your registration, or I have a survey scheduled to go out to you. It has a question on there about CEUs too. Just email me with your information and I'll forward it to the proper parties. So I want to thank Hannah for coming and speaking to us tonight.
Absolutely.
Taking time. And we have Jim Harper here. I'll look up his email here in a minute and get it in the chat box. But he's with Montgomery County. He helps with the guardianship pieces, with the intake and with Montgomery County, but he's a great resource for those who have questions as well. So let me go ahead and end this recording. And again, thank you all for coming. 1 second.